But it really, when it comes down to it, all you can do is provide all of the information possible to the client and say, this is what I suggest, and help them come to their own decision. Because whether or not they want to take the risk, it's up to them. We have an obligation to explain to them what the risk is, what the value of the case is, what it really means to accept a settlement now, to accept a settlement later, maybe in mediation, or to really try to go to trial, which means we could get nothing or we could get a whole lot more than what they're offering, and tell them, based on my experience, what I've seen and all of the reading I've done, other attorneys I've worked with, I would say the chances of us getting more than the settlement are about 80%, but I can't guarantee that.
Welcome, ladies and gentlemen, to the Modern Lawyers Podcast. I'll be your host, your lawyer, Ali, and I'm here with trial attorney Corey Hall. Welcome.
Thank you.
How are you doing today?
Really good, especially now that you gave me a cup of delicious coffee.
How many cups do you drink a day?
Ooh, embarrassingly enough, I've cut back to 4.
You cut back to 4 from what?
At my peak.
In your prime. I want to know about your prime.
In my prime, honestly, I was doing about 10.
10 cups of coffee.
Yeah. I've got 2 little kids, and it's also it just feels so good.
Do you eat during the day too, or is it just coffee?
I'm starting to eat now.
Okay. I know a lot of people have concerns about this. Are you able to sleep when you have that much caffeine?
I wasn't sleeping very well, no. I got the Apple Watch, and it was showing me how much I was actually sleeping and how much I was waking up in the middle of the night. And that, among many other factors, is what made me decide to cool my jets.
Do you remember how much you were sleeping when you're looking at the Apple Watch, when you're having like the 8 to 10 cups a day?
It would be about 5 interrupted hours.
5 interrupted hours.
Yeah, that's the problem. It's not getting the consistency. So it would be sleep for 2 hours, get up, sleep for 2 hours. And it was weird. The next day, I wouldn't really remember being awake. And then when I got the Apple Watch, I would see that I was waking up. And then I would kind of reflect more and be like, oh yeah, I did get up for a second, or I grabbed a little glass of water or something. But I would just forget it the next day.
Sure.
Probably because I was sleep deprived.
I get that. Were you dreaming, or are you remembering your dreams?
No.
Okay.
Just a dark abyss.
And now you've cut down to 4, that's 40%. You're at 40% right now.
Yeah, I cut down 60%.
Yeah, that's amazing. So what's the sleep like now? Do you still have that Apple Watch, or you have to sell it on eBay?
Do. No, fortunately. I'm getting about 7. I'm shooting for 8. It's hard.
So 7 with 2 kids.
With 2 kids.
I think that's pretty good.
Yeah, I mean, it's much better than before.
Has it affected your work product as a lawyer, as a parent? Are you more pleasant to be around?
Yes. Working is more pleasant. So I wouldn't say the work product necessarily was suffering. Probably was a little bit. I think that's inevitable when you're sleep deprived. But for sure, my outlook and the enjoyment and satisfaction doing the work, night and day.
Amazing.
Yeah.
So you call yourself a trial lawyer. What does a trial lawyer even mean?
A trial lawyer is a lawyer that takes cases to trial, preferably in front of a jury. And it's unfortunately, fortunately for me maybe, it's a dying art.
Mm-hmm. Why is that?
Well, I think the costs of litigation have gone up astronomically. I think that's a big factor. But I think with that, ADRs become much more prevalent. There's just the industry standard is kind of work up a case, settle it. So people aren't even really looking at getting to the actual finish mark, which is trial. But then I think because cases started settling more and there's much more mediation, arbitration, that learning how to try an actual case kind of became a skill that people didn't think was necessary. And then now if a case does end up having to go to trial, which obviously not every single case is going to settle. Sometimes people have differences. Sometimes one of the parties, typically the insurance defense, is being really unreasonable, calling your client a liar when there's no evidence to prove that. And sometimes they kind of put your back up against the wall and you have no choice. It's like settle for 10% of what the value of the case is, or go to trial and get the full value.
Sure. So you just said something. You said you don't have a choice, but it sounds like you do have a choice. You either settle, take as low as possible what the insurance company's offering you, or you try your day in court.
Yeah, I mean, if I held a gun to your head and said, give me all of the money that you have or I'll kill you, technically I'm giving you a choice, but it's not a really pleasant choice.
I'm not the guy to do that too.
Anyone. You can cut that. Yeah, I mean, obviously there's still a choice, but if the client wants to take that, as long as you're communicating as an attorney, hey, this is what I value, maybe 10 to 15% of your case. I think if we go to trial, we can get a lot more. I think you deserve more. But ultimately, it is the client's decision. But I don't think they're giving them, in a lot of cases, too much of what are they going to do? It's just settle for 15% or go to trial. I don't see that as being...
So generally, I would say the insurance company will give you that sweat zone offer that makes it difficult for the client to go to trial. It makes it very attractive for the client to settle. But if you're not getting that sweat zone offer, that offer that makes you sweat, and it's that low, the decision's almost made for you.
For me, yeah. I think there's a lot of attorneys. This is an unfortunate result of everything I was talking about before, the increased costs of litigation, the decrease in trial skills, is that a lot of attorneys don't know how to take a case to trial. So they have this case when they're really, what I'm saying is not much of a choice. But if they don't have the skill set to take it to trial, what are they going to do? They're either going to, one, which they should do, send it out to a firm that does do trial work, such as your firm would be a great option, or B, and what happens much more frequently, and it's really, really to the detriment of the client, and it's unfortunate that this happens, they'll press the client to settle their case. They'll find all the reasons why trial's such a big risk. Well, you remember the O.J. Simpson case? A jury can do anything. Well, you said you had back pain back 7 years ago. They'll just lean on them. And the reasons for that is they don't want to fee split with another attorney, and they just kind of want the case to go away.
Sure. I always hear it's always better to have cash in hand, right? You always tell your client that. I hear people tell their client or lawyers, it's better to have cash in hand. And what does that even mean, cash in hand?
I don't know. I mean, it's, hey, you have $1 or take a 20% risk to get $20,000. I think it's kind of a no-brainer, but yeah, it doesn't mean anything. You're right.
Sure. And it looks like the client needs to have an attorney that has confidence, right? It's Dumbo used to fly, right?
Yeah.
But the lawyer is actually that feather. That lawyer is what gives the wind to the sail to the client to say, I want to take this case to trial because I believe in my lawyer.
Exactly. And also believe in myself. Unfortunately, when I was talking about lawyers leaning on the clients to settle, what they're trying to do really, a lot of that is undermine the integrity of the client, even though they're not going to directly say, you seem like a liar, but it's, well, we could have credibility issues. The jury might not look. Really what they're saying is, you're not likable and people aren't going to believe you. And if that is actually the truth, we have an obligation as trial lawyers to educate our clients about that and say, hey, there really is a risk. You testify to this in your deposition. We have this document that says this. Those aren't really consistent, and that will look bad. If you're doing that because your client maybe has unrealistic expectations or wants trial, which is pretty rare, but it does happen, we have to rein in their expectations. We have to rein in and show them, hey, this is what is likely going to happen. But what we're talking about here is when the lawyer who's never tried a case, who's never been in front of a jury, is scared and doesn't know what to do, and therefore just pushing and leaning on the client to lower. they'll just accept anything.
Sure.
Hey, just take $1,000 and go. That's not, why even get a lawyer at that point?
Exactly.
I don't understand it.
And just piggyback off of that, what's some advice that you'd give to lawyers that are afraid to take a case to trial?
Well, it probably could sound like what I'm saying is disparaging to attorneys who don't know how to try a case. The first thing I would say is, of course you don't. It's a dying art. Not many people do it, and it's okay. It's fine. It's terrifying trying a case. It's terrifying. It's honestly the most nervous I've ever been was the first time I stood up to do jury selection. I started kind of blacking out it was just crazy. I don't even know how to explain it. I was just so nervous. It's really scary. But there's so many firms where there are attorneys who do know how to try cases. So if you have a case and they're putting you up against the wall and not giving you much of an option, talk to another firm, shadow them, go to trial, or you could just give all of your cases to them. But I just think what I would say without question is you should never push your client to take a settlement because you, as the lawyer, don't have a certain skill set. That is not what we're supposed to do. It undermines the entire integrity of this profession. And it's a disservice to the clients, which is most important, but to the lawyer themselves. That's a disservice to you. You're stripping your own self of dignity and honor and all the beautiful stuff that comes with being a member of this profession. You're undermining all of that. And so I don't understand why people do it. I really don't. It's easy to avoid.
That's powerful. I love that. It undermines the integrity of our profession.
100%.
Now, it's impossible to always win, right? Even the best of the best, they don't always win. So how do you prepare yourself to have that conversation with your client? Or I know it's not an easy conversation because on one end, you need to be that confident pit bull that says, hey, I'm your soldier, I'm going to fight for you. On the other end, you need to give impartial advice where the client totally knows what they're getting themselves into. So, how do you have that conversation?
Oh, 100%. There's one of my favorite quotes is you're not a real trial lawyer until you've won cases that you absolutely should have lost and lost cases that you absolutely should have won. And it's true. And it's also very irresponsible to not educate your client about the risks of trial. Trial is risky. By definition, it is risky. That is true. When I was critiquing the idea that they're bringing up how risky trial is and all this stuff, the critique of that is to use that as trying to persuade your client to almost settle their case for nothing, for whatever they'll give because trial's risky. Mm-hmm. It's a little nuanced, but I think it's a very important one. You're, I guess at the other extreme, you're being just as reckless and just as bad of an attorney if you're not properly educating your client as, to all of the risk involved. This is an area that I personally have struggled with, and I tell clients right away, up front, I say, I almost have a conflict of interest with you because I want to go to trial. I'm going to give you the best advice I can, but I have had to check myself for real at times where I've been a little, nonchalant about there is risk, but come on. So I think in our profession as a whole, it's definitely going to be the other side where they're talking about all the risk to really push their clients to settle for less. But personally, yes, I have struggled with that, and I feel like I'm getting much better at it. And cases are going to go to trial. People will bring me in to try cases. I want what's absolutely best for the client, and the best way to get what's best for the client. Here's the most important thing to remember. The client decides. It really ultimately to accept a settlement or not, it's a personal decision. It really is. It's a personal decision, which seems weird because clients ask me all the time issues that are really personal. Do you think I should work at this place or this? Well, what are you interested in? I don't know. But it really, when it comes down to it, all you can do is provide all of the information possible to the client and say, this is what I suggest, and help them come to their own decision. Mm-hmm. because whether or not they want to take the risk, it's up to them. We have an obligation to explain to them what the risk is, what the value of the case is, what it really means to accept a settlement now, to accept a settlement later, maybe in mediation, or to really try to go to trial, which means we could get nothing or we could get a whole lot more than what they're offering, and tell them, based on my experience, what I've seen and all of the reading I've done, other attorneys I've worked with, I would say the chances of us getting more than the settlement are about 80%, but I can't guarantee that. Mm-hmm. And then the client has all of the information they need to make their decision.
Totally, I totally get that. You know, it's a going rate at the firm. We call attorney Corey Hall. He's the friend that's always down to fight. Anytime you need a little bit more backup, Corey's down to fight, and we all appreciate you for that. So that's really cool.
Well, thank you.
So tell me this. In a situation where you disclose everything to the client and the client wants to move forward, okay? Heaven forbid you get a jury that's not favorable or something just doesn't go it just wasn't your week. What could the client be responsible for? Is it just everybody walks away? I mean, what's like a bad case scenario for a client if you lose a trial?
Well, it depends on a lot of factors. That's the ultimate lawyer answer. Well, it depends. There's a provision of the Code of Civil Procedure 998. And so if the defense sends you what's called a 998 offer to compromise, let's say they send you a 998 offer to compromise for $25,000, and you think, you know what, I think this case is worth about $150. And you go to trial and you get $24,000. The client, not the attorney, the client is responsible for paying all of the expert costs that the defense had to pay from the time of issuing that 998 offer. The legislature created this statute to incentivize settling. Hey, another reason why more cases settle and don't go to trial. So if there's a 998 sent and it's refused, then the client can potentially be on the hook for the expert fees. And that is, I mean, obviously, if that's something you receive in a case, that's something you need to be very clear about with the client and explain. That just kind of goes into the whole cost-benefit analysis. Hey, here's the risks. Here's what losing looks like. You don't skim over it. You really talk about it. Hey, we could lose. Nothing's certain. And in litigation, especially, nothing is certain. I think we have a good chance at prevailing, but I need to go through everything that could happen if we lose. And then boom, boom, boom.
I see. Does the defense actually execute on that? So if, heaven forbid, somebody loses at trial and they lose the 998, so they get an offer or no offer below the 998 of the defense, are they actually going to come after, your poor client?
Not my clients.
Because you don't lose.
For real. No, because I say, we'll waive costs, no appeal, everybody goes away, we're all happy. And I've never had them not agree to do that. I've heard of instances where that's happened, but here's the thing, man. Honestly. I mean, it could happen. I believe the instances that I have heard of that happening in are with very unpleasant plaintiff's attorneys. And I'm really big. Look, I'm aggressive. I like you said, I'm always in for a fight, but I'm not going to be disrespectful to someone. I'll say, I think you're wrong, and I think my client deserves this, and here's why. But I'm not going to make it personal between me and the attorney. If they ask for an extension, I'm not going to be unreasonable and not give it to them, unless, of course, they're pushing back the trial date, doing something that substantially interferes with my ability to represent my client. But I try to have good relationships with defense attorneys. And I think I really do, honestly. Obviously, their client is going to have some input as to whether or not they would waive those costs in agreement for not appealing. But I'm telling you, that defense lawyer is going to be a big integral part of that and their recommendation. And if you have a good relationship with them, it's infinitely more likely they're going to go to bat for you.
I see. I like that. So you're going to run into these lawyers again, and it's important to keep professional courtesy and just be professional all around.
100%. These are the people we are asking for money from. We're trying to get them to pay our clients money. I mean, there's so many arguments to be made for why we should be professional.
Sure.
You know, you've heard the saying, you get more flies with honey than with vinegar. But it's just so true in this profession. I'm asking them, if I'm being unreasonable and a jerk, it's just human nature for that defense attorney to want to dig in his heels and just jam me up and make my life as hard as possible. And this profession is already hard enough. Why would I want to do that? But more importantly, if I'm letting my ego and my fight with the defense get in the way, what I'm really doing is hurting my client. I'm not putting my client first. I'm putting my ego above the client. And that's not something we should do as attorneys. And it's easy, especially for young baby lawyers. Any baby lawyers watching this, tone it down, please. I just got a letter from a new attorney on a case I filed. The person was on the Secretary of State website as being a part of the corporation. This guy sends me a letter. I'm going to sanction you personally, the judge. Just this like violent letter. When he could just say, hey, could we have a phone call? I'd like to tell you why I don't think my client's liable. And I read the letter. I knew he was a new lawyer. And then sure enough, he'd been practicing for less than a year. But I used to probably be much more aggressive, much more unprofessional when I was young. And I'm just telling you guys, it doesn't work, especially with us, because we just dig in our heels and fight. And we don't have a client overseeing us saying, hey, why are you billing all this time for that? Right. I can spend as much time as I want jamming someone up.
Right.
I don't want to, and I try to just absolutely do everything in my power to avoid that now. But I know there's a lot of attorneys who get into the ego match, and they rather than trying to rise above it all, they just get sucked into it.
Well, how do you balance that as a new attorney? You want to make a name for yourself, you want to be aggressive, but at the same rate, you don't want to come off crazy.
Well, it's being aggressive is not. I mean, I think of this is a weird analogy, but I think of the person that I'm personally scared of in the world is not the person who's like, come on, bro. It's the guy who's just sitting there quiet with a stern look on his face, and he's just watching you and analyzing your body language. That's the guy I'm actually scared of, right? And so I think that the same holds true in the law. If you don't need all these threats. I'm going to do this and then a motion to compel that. Just say, hey, you didn't give me my documents. When can I expect to have them? Hey, I'm willing to give you another extension, but honestly, I need to get this stuff, right? You're firm. You have confidence in your case. That's a form of, we need to be aggressive. We need to be aggressive. I think that word is just too ambiguous because, you don't need to be stupidly aggressive or like violent or jingoistic or like unnecessarily argumentative. You can be firm and confident and calm and still get what you want. And I think it's a more respectful way to treat someone, and they'll end up respecting you more. So they'll be like, okay, this guy, he's not the guy just, bro, right? That person doesn't know how to fight. That person doesn't know how to do anything. The quiet guy is like, all right, man, it's gonna be like 5 to 10. All right. That's the person.
It's all growl, no bite. I see that with a loud person.
The empty barrels, empty vessels make the most noise.
Yeah.
And it's true.
Fair enough.
Yeah.
Tell me this though. I think it's a old wives' tale. I mean, for anyone that wants to become an attorney, wants to get into the profession, they think that either you have to have very rich parents or you need to have a lawyer in the family. I mean, what's your story? How'd you get involved? Is that true?
Yeah, I think that's true.
Yeah?
No. This is a setup. No, I'm from Northern California. I'm from 3 hours north of San Francisco, way out in the boondocks. I actually grew up in a double-wide trailer with no electricity. Did not come from money, like any stretch of the imagination. And I got in a lot of trouble in school. I was fun bad.
Yeah.
I was the fun kind of, I was just the class clown, but honestly, I had solid Fs all the way up into high school.
Consistent?
Consistent. I was consistent. but no lawyers in the family. This is true. I'm dead serious. I tell people this sometimes and they don't believe me, but this is the truth. I did not, and I mean this sincerely, I did not know what college was when I was a sophomore in high school. I didn't know what it was. I was like, what do you mean college? I don't know what that is. I'm like, oh, it's like school after school. What are you talking about? It made no sense to me. And so by a bunch of very lucky just coincidence and just opportunities that I got on track. I took all 4 years to get into a university in 2 years, and then went to college, went to law school. But no, you don't have to have money. There's financial aid, there's student loans. I think you just have to, obviously you have to work really hard. I don't think it matters how smart you are. The smartest guy at my law school went to UC Hastings, and he was number 1 in our class, and he transferred to Stanford. And this guy was a brain. We called him Bobblehead because he would kind of do this in class all the time. But he was just brilliant. He didn't pass the bar the first time he took it. And I can only accredit that to him just not working hard enough, because he had
brilliant.
He was brilliant. He had a legal mind. He would even impress our professors. He just was a brilliant, abnormally brilliant guy. So you obviously have to work really hard, but I think if you're driven, and I think more importantly, and especially as you're into the profession, but I think just trying to find a deeper meaning as to why you're doing it. I think there are a lot of miserable attorneys. It's known as being a profession that has a really high rate of depression and anxiety, just other mental illness, addiction. I think the reason why is because in our society, it's either you become a doctor, or if you're not good at medicine, you become a lawyer. It's prestigious, it's well thought of. And if you're choosing the profession for that reason, don't do it. It's the wrong reason.
It's empty, right?
It's total. This is a hard job. People don't realize how tough this job is. I love this. I feel so blessed to be in this line of work. I don't think there's anything in the world I could ever do that would bring me this much continual joy, excitement, stimulation. But man, I have days where I have nothing left in me. I go home and I'm just like, I'm so tired. I can't even watch TV. I can't do it. I'm just done. You know what that feeling is like. It's a grind. People don't realize, and especially when you throw in, which I know will resonate with you, being a business owner. You're a really good lawyer and you're a business owner, and you're running an amazing shop here. I'm really impressed.
I appreciate that.
I mean it. It's very impressive. But it's if you don't have that deeper passion, or you don't find meaning in what you're doing, the idea of justice, of righting a wrong, of being able to fight. I love let your voice be heard, because it's true. You're representing people who haven't been able to tell their story, or they don't have the tools to be able to. And you go in and you talk to a jury and you tell them, this is what this did to their life. This is how this affected them, right? And you're the voice of your client, and you're the vessel through which their story is told. And that's meaningful, it's deep, it's profound. But if you don't care about those kind of things, and it's fine if you don't, it's fine. But if you're just becoming a lawyer because it's prestigious or it pays well, God, of course you're gonna be miserable.
And there's easier ways to make money.
There's way easier ways to make money. Though that's the paradox of it all. If you're just doing this, if you go into the law to make money, you will not make money. I promise you that. Hold me to it. Tell your parents.
Hold them to it.
It's true though. You won't. If you're just focused on money, you're never going to make money in the law. You have to have something deeper. You have to have something that connects you to your clients, your purpose. Even if it's, I'm going to be honest, sometimes I feel a little, disappointed in myself that I do find myself at times, we've talked about this before, I'm exclusively focusing in employment litigation now. And part of the reason why I wanted to do that is with the personal injury cases and the employment cases, I have the same level of compassion and care for the clients. I like them both. It's not like I like employment clients more, but it's the bad acts of the employer just resonates with me. Sometimes, not in all cases, and the insurance company certainly can be a source of, I want to go after you. But sometimes, I had a case where a guy was driving, going to coach Little League. He was, an upstanding member of the community, and looked down at his cell phone and rear-ended someone. And he should pay for what he did. And his insurance company certainly should not be calling our client the liar. There is a moral truth there. But the guy, the actual actor, was a nice guy. I liked him. In that case, honestly, I liked him more than my own client. My client was not very nice. And this guy was just a gentleman. And I'm sitting there and like, I hate your insurance adjuster, but I like you. I've never had that in an employment case ever, never even close. And I'm very motivated. And sometimes I feel like maybe I should be more motivated by caring about my clients. I would say it's probably equal. And I don't feel great about that, if I'm going to be honest, but it is what it is. I'm just being honest. But I get a great deal of motivation when I see employers mistreat their employees. I mean, it fires me up.
Right. I mean, like, everybody gets their inspiration for something, so I don't think that's wrong. Especially in an employment scenario, you have the superior bargaining power of the employer, and you have these employees, and they have to be under this dictatorship, this reign of this individual or company or authority. So I can imagine, I can see, you want to bring that fight that they can't bring alone.
Exactly. That's the in those cases especially, because while they were at the mercy of when you said the unequal bargaining power, oh my gosh, that is what resonates with me. When you're an employee, the employer can get rid of you if they're even bigger than a 20 employee company, and not really feel that big of a difference. When you lose your job, you lose your ability to maintain your life. You can lose your health insurance. You lose everything, right? And so the employers know that, and they take advantage of it a lot. And a lot of employees do just suck it up and have these wrongs committed over and over and over again, and they're not allowed to say anything because they don't want to lose their job. They don't want to get fired. They want to keep their health care. They've got kids they've got to support. They have people dependent on them. Yeah, you can see it really does. It resonates with me, for real. It does. And so you're helping them, even if it doesn't go to trial, even by filing the complaint. You're listing everything that happened that they were never able to confront their employer with,
right?
And they're finally confronted with it,
right?
And that is amazing. It is. I just love it.
Yeah. Well, I have a question for you, and I know we get a lot of phone calls for this. We have employees that are disgruntled that still work there. I mean, is there a case there? Is there a case if you still work somewhere and you haven't pulled the trigger, you haven't been fired? Would you take a case like that? I mean, what would be your advice? And I know, disclaimer, you're not giving any legal advice here, but what happens when someone's working there? Because in my head, I say, well, how bad could it be if you're continuing working there?
I no disrespect. I think that's the wrong way of looking at it. Yeah, because it's such a major life interruption if you have to get a new job, major, and people are scared. What if I'm not employed? What if they really can't? What if they have a daughter with a medical condition who has to have medical insurance, and they don't know how long it's going to take them to find another job? So I've thought that exact thing before. And then speaking with clients more and just working in this field, this area of law more, I've realized, no, if they're staying there, it's not necessarily an indication of it not being a bad environment. Some of the craziest, most shocking cases I've ever had were over a series of maybe 6 months where, just one of the defendant's acts, you would be like, that is the craziest, and it's over and
egregious.
Over. Egregious. And I do ask, I always feel uncomfortable asking that question. It does feel a little maybe like victim blaming, but I want to know it's important for the case too. Why did you decide to stay here? And every single time, I swear, there's a good reason. I had to, one of the cases, I gave the example of the medical care for the daughter. That's actually from a case that I had. Wow. My daughter has a medical condition, and she has to get a certain treatment every month and a half. What am I going to do if I lose health care and I don't find a new job and I can't afford the COBRA? What am I going to do? And it makes sense. So Yeah, I mean, if they're still there, you're going back to the original question you were asking. If they're disgruntled, is there still a case if they're still there? It depends on what type of case. If there's a wage and hour, if they're wage and hour violations, 100%.
Sure.
Yeah. If there's sexual harassment, that's ongoing, 100%. Yeah. You don't have to be terminated to have a case. And in fact, in California, there's a thing called constructive termination. It's a relatively high bar, but it's basically that the working conditions are so bad, and they really have to be bad. They're so bad that no reasonable person would stay at this job. And the employee can quit, and it's under the law considered a termination.
Interesting.
But in that scenario, they wouldn't still be there. But if someone is still at a place of employment, yeah, there's all types of cases that they could currently have. Failure to accommodate is very common. I get a lot of calls where they're like, I'm working here. I've asked for any type. I mean, gosh, California employers are so bad at accommodating. They hire these outside agencies, Cigna, what have you, out in New York, New Jersey, and they're applying federal law. And they just do not understand whatsoever the nuances of California law. And I get it. California employment laws are tough.
Sure.
They're tough against the employer. I think philosophically I agree with about 98%. But there's somewhere I'm like, man, this is really, I'm also an employer. And I'm thinking, this is hard to comply with everything. But here's the thing. If you want to do business in California, you have to follow California law. And so these guys, I had a lady, she was with Cigna. I don't know if you would call her an insurance agent. I don't know what she was, but HR specialist. She's like, it's unfair. I'm like, wait, you're talking, well, hold on. You didn't accommodate my client, but let's just forget about that. I'm not here to talk about what's fair and what's not. You're in New Jersey. Your business is making a ton of money from California. Follow the law.
Right.
We residents in California have elected people in the legislature to pass laws that we collectively agree on. That's democracy. I mean, I just don't understand what she's even getting at. It's not fair.
I hear you on that. I like that. And something that you just mentioned right now, constructive termination. I mean, we represent the people, and I think everybody wants to know this. Can you file for unemployment if you're constructively terminated?
You can if the employer, here's the thing. If the employer challenges it at the first level, the first initial hearing, I would say there's about 95% certainty that they'll deny your employment. But if it goes up to the appeal, I would say with 95, I mean, I can't say in a bubble. If it's what I consider a constructive termination, I've done 40 of those appeals. I've never lost one.
Wonderful.
Yeah.
So technically, it could be such bad working conditions that you were forced to quit. I mean, that's what constructive termination is. And as far as unemployment goes, that would be the equivalent of a termination.
100%. So all things being normal, not the constructive termination situation, you will be denied unemployment if you quit voluntarily or if you were terminated for misconduct. Now, a lot of times you'll see people challenge the unemployment and be like, oh, no, it was misconduct because he was rude. Misconduct is misconduct. It's a high standard. I mean, yeah, embezzling funds from the company, that's misconduct. Sexually harassing another employee, that would be misconduct. But most terminations aren't going to fit that. So it's a voluntary resignation or voluntary resignation will preclude you from getting unemployment. A constructive termination, even though you quit, technically, the law doesn't look at that as voluntary, that you had no option. Remember how we were talking about choices earlier?
Sure.
I said, hold a gun to your head and give me money. I'm not really giving you a choice, right? You don't have any choice except to give me the money. And in that situation, yes, they left their job. They quit their job, but no reasonable person would stay in that job. That's not a real choice.
Right. The consequence is so bad that you don't have a choice.
You don't have a choice. You don't have a reasonable choice.
Yeah. I hear you on that.
It's Sophie's choice.
Sophie's choice. Well, Corey, I appreciate you coming on today.
Absolutely. Thanks for having me. This is good.
Yeah, absolutely. Everyone, thank you for staying tuned. Wait till next week. We got another great guest, so hang tight, and I appreciate everyone. Cheers.